Okay. Ah, God, the frame is wider. Let me check it through your phone. It's better now.
Yeah.
That's it. Okay. I forgot to put on my system. Am I in the frame?
Yeah.
Very good. Good morning, ladies and gentlemen. Just give me 1 minute. I have to put on the system. So good morning, guys. Today we are talking about terms of contract. And for those who are coming to my channel for the first time, this is Olayeni Dear Kolola Daniels. I'm very sure you'd have heard that name once or twice. Yes, I'm trying to get the notes in order. Yes, and today we'll be talking about terms of contract. I hope everybody can hear me. Please let me check if people can hear me. How do you know that? How do you know if they can hear me? Today we'll be talking about terms of contract. I believe that everybody can hear me and I am as sound and clear as I can be. You know. Good. Okay. So yes, once more, welcome to today's episode of Dear Court Talks Law. And on today's episode, we'll be talking about terms of contract, right? So there are 4 things that we're going to be talking about today. We are talking about the definition of terms of contract, so to say, not like there are definitions, but we'll go through what we mean when we say terms of contract. We'll also talk about mere representations. Very importantly, we'll talk about the significance of the distinction between mere representations and what to be regarded as terms of contract. And we'll also be talking about how to distinguish between both elements. And lastly, we'll be talking about collateral contract. So this is going to be the first class of series of classes where we'll be talking about terms of contract as a whole. We also are going to talk about what's it called? Conditions and warranties. We'll talk about innominate or intermediate terms. We'll talk about fundamental terms. These are lectures on their own. And then later we'll talk about the implied terms. That implied by trade, implied by statute, and implied by court. Do you understand? Those are the classes that we are going to be having on this topic of terms of contract. But today is just the introductory class where we'll be talking about definition of terms and distinguishing between mere representation and terms of contract. So if this is your first time of coming to my channel, please do not forget to click the subscribe button as well as the notification bell so that anytime I have classes of this nature, you will get notified as soon as possible. So with that, I think that we are all set to go straight into our lecture for today. So I want to believe that everybody is following. Manager, help me check if everybody is following. All right. Okay, good. So now moving on, we are talking about terms of contract here, and if you are in this class learning terms of contract, it means that it is taken for granted that you know what offer, acceptance, consideration, intention to enter legal relations are. Do you understand? Is there any problem? Yeah. So you know what offer, acceptance, consideration, and intention to enter legal relations. So just a recap here. So you say you have A and you have B, right? Now A told B that, oh, I have birthday coming up soon, and I want you to give me a 3-layered cake, right? And B is the cake maker. I'm going to pay 500,000 naira, right? So you have offer. A is making the offer to B that A is going to pay 500,000 naira for a 3-layered cake. So you have 1, 2, 3. This is the cake, right? A 3-layered cake, 500,000 naira, and that is what B, the cake is what B is supposed to give to A. So if you are looking at offer, has there been a valid offer? Yes. 500,000 naira for cake. Has there been a valid acceptance? Yes. B says, okay, no problem, I'm going to do it. Then A says that her birthday, what's today's date? Today is on the 8th. So A says that her birthday is on the 8th of December 2022, and that's going to mark, let's say, 20th birthday, for example, right? Now, she's saying that B should make sure she sends the cake across to her by latest on the 7th, right? That's number one. Number two, she also said that a 3-layered cake, she wants the top to be red velvet, she wants the middle to be chocolate, and she wants the one under to be vanilla. Do you understand? Red velvet, chocolate, and vanilla. So now, can you see that while we are talking, we have been saying a lot of things, right? We have talked about the dates, we have talked about the arrangement of the cake, and we've also talked about the subject matter itself, which is a cake, right? So there are 3 things that we have talked about. The date of delivery, which should be on the 7th because our birthday is on the 8th. We have talked about the subject matter of delivery, which is the cake, and we have talked about also the arrangement of the cake. So when we are talking about terms of contracts, in all these things that we are talking about, so to say, if B fails to deliver on these 3 things, what are the 3 things? The dates, the subject matter, and the arrangement of the cake. If B fails to deliver on these 3 things, right, can A decide that, okay, because you did not, let's say B delivered the cake on the 8th as opposed to the 7th, then A is saying, no, I'm not going to give you your 500,000. Or let's say B delivered on the 7th, yeah, which is supposed to be the delivery date, but instead of delivering a cake, B decided to deliver, let's say, buns and puff puff, for example, and not a cake. What's the subject matter of the contract? A cake. But he delivered on the 7th, so we have dates, click, right? But the subject matter of what was delivered was what? Was just merely puff puff and buns as opposed to a cake, right? Or let's say he delivered on the 7th and then he delivered a cake, you know, but the arrangement, instead of red velvet to be up, it was vanilla that was up, the red velvet is middle and chocolate is down. The arrangement got muddled up. So if B fails to fails to do one or more of these things, can A say, because although you delivered a cake to me like I've asked, you delivered on the date to me like I've asked, but instead of delivering based on the arrangements, you delivered it muddled up, I am not paying your 500,000 naira. Can A say that? Or instead of you to deliver on the 7th, you delivered on the 9th and my birthday was on the 8th. Because of that, even though it is the subject matter cake, even though it is the same arrangement like I asked, but I will not give you the money. Do you understand? That is an example of what we talk about terms of contract. There are certain terms that if B doesn't do, A can say, I am not going to do this contract with you again. Do you understand? Like, I'm not going to pay your money. If, for example, the date, can A say, I'm not going to pay your money because I told you 7th, I are delivering 9th. Do you understand what I'm saying? So, or the subject matter, I told you that I wanted cake, you are giving me puff puff and buns. Or the arrangement. So, you know, that is what we are talking about when we say terms of a contract. There are 2 types when we advance. We have condition and warranties. Condition are such that when they are broken, you know, which means breached, you know, breached, A can say, I am repudiating. When you hear repudiate in a contract, repudiate, it means I am going to take that contract as if it never existed. I am not going to pay your money or discharge any responsibility which I ought to do. Do you understand? That is what it means to repudiate a contract. Do you understand? So when a condition has been breached, A can repudiate a contract and say, I am not going to pay your money, and in fact you are the one that is going to pay me damages for breach of contract. However, we have another which is known as warranties, which is the fact that although A can say that, you know, A can say that he's going to repudiate the contract, but he can collect damages for the breach of that term. Before we begin to go deep into those terminologies, let us come back home and talk about, you know, mere representations and terms of a contract. So terms of a contract, mere representations. Let's go to the definition, and while going to the definition I have to read through my notes. I sent the note to the group chat for those of us in the contract law group chat and all that. For those who are not in the group chat, who join the class online, you know, and all that, you just listen to me, you will be able to follow what I'm saying. It's just basically the notes. So yes, given that a valid contract has been concluded, the next matter of importance is to determine the extent of the obligation undertaken by the parties to the contract. This will itself involve a consideration of various factors. For example, apart from the express terms contained in a contract, like these are the express terms, the parties' responsibility may further amplified by other terms such as implied terms. Now, implied terms are things I'm going to be talking not in this class. I wouldn't be talking about them in this class. I'll be talking about them in other classes. But I'm just trying to let you know that we have express terms like this. We also have implied terms. You know, I don't want to go into the details of the implied terms, but we'll be talking about them in other classes. Thus, terms may be implied by the usage or custom of a particular trade, and unless they are expressly or implicitly excluded, they will be regarded as forming part and parcel of the transaction. Again, the full extent of the party's obligation in a contract cannot be accurately determined until the terms are classified and evaluated. So what do we mean by that? We are saying that when we have certain terms that have been broken, we do not know the effects of the breach. When you're looking at terms of contract, there are two things that I want you to look at, which we are going to be teaching through in the class. We are going to be looking at what is the clause, right? What is the clause? So, for example, let's say the clause is the date. It should be paid, the cake should be brought 7th of December, right? Now, what is the effect of breaching the clause? Those are the two things that you need to look at. What is the clause and what is the effect? Do you understand? There's a third thing here, actually, in the middle. What is the clause? What is the nomenclature of the clause? That's the nature of the clause. What is the clause? What is the nature of the clause? Then what is the effect of breaking the clause? Do you understand? If the clause is as to dates, right, that you should give us 7th and then you gave 9th, whereas the birthday was 8th, the court will construe, is it a condition, right? When we look at the what is the clause, then we look at the nature of the clause, then we look at the effect. If the clause, if the court calls it a condition, then the effect will be such that it can repudiate, right? We are going to go into more details, but I just want you to think, when you're talking about terms of contract, I want you to think in relation to this. What is the clause? What is the nature of the clause? And what is the effect of breaking the clause? Do you understand? So let's move on. Terms are not all of equal importance. They range from fundamental terms, that's the most important, we'll talk about that later, to warranties, the least important, we'll also talk about it later. In between these are conditions and the subsequently identified innominate or intermediate terms. We'll also talk about that later. Thus, the extent of a party's obligation and the consequences of a breach can only be correctly assessed after determining the nature of the contract. Finally, it may on occasions be necessary for an aggrieved party to be advised Finally, it may on occasions be necessary for an aggrieved party to be advised whether a term for whose breach he wants to sue was a term of a contract or a mere representation. Thus, in the process of negotiating an agreement which leads to the conclusion of a contract, the parties may have said or written many things. When the contract is concluded, it is a question of construction whether some of the things said during negotiation become part of the contract or were mere representations. This will determine what the course of action will be in the case of a breach of the contract. This is a preliminary issue which deserves to be considered first. Now, before we go into the latter part of the notes, when you are talking about mere representations, if you have been to Yaba before, for example, and you know all those marketers, all those Igbo marketers, when they buy what they are selling. So, for example, you just see somebody while you are walking around Yaba. It doesn't just happen at Yaba. It happens almost in every market in Lagos, and I don't know what part of the world you are. But you will see that there are some people that will keep telling you, you want to buy jeans? You want to buy jeans. They sell jeans, so this jeans original okrika. If you put them inside fire, you know go burn. You know all those kind of things that you'll be saying. Like it's original, you use it for the next 5 years, 10 years, it will still be like brand new. All those words. You guys have not started talking about the contract though, right? There's no offer and acceptance yet, but we are still talking about the preliminaries. Do you understand? So they will keep making so many representations. Is original, is this, even if you want to buy a phone or you want to buy anything, the seller will always tell you is original. Something where we import from China, something where you get. So all those words being said by the other party to a transaction, when the other one then enters into the transaction and sees that those words are false, what would the other party do? Can the other party say, you told me that this thing is original, that they brought it from China, that I will use it for the next 10 years, and I used it for just 3 months and it don't spoil, I not do again, come carry your market? Do you understand? Can that party say, I not do again, come carry your market? That's basically what we are talking about when it comes to terms of contract and mere representation. So let us go to the note where we are talking about a term of a contract and mere representation, the significance of the distinction. Now, the importance of the distinction between a term of a contract and a mere representation lies in the type of remedy. Do you see that? Lies in the type of remedy available to the aggrieved party when the breach of contract is alleged. If the breach is of a term of contract, then the aggrieved party can sue for a breach of that term and obtain a remedy in damages or in both damages and repudiation, depending on the importance of the term. So, like I told you, when you're talking about term of contract, you have what? When a term of a contract has been breached, you have either condition or warranty, which will allow you for repudiation and damages, or repudiation or damages, or just damages. We'll talk about that. When a term of a contract has been breached, the effect of it is that the innocent party can repudiate damages, or if it's a warranty, not have the right to repudiate the contract but can claim damages. Do you understand? That's the effect of breaking a term of contract. But a mere representation, not only is a remedy available to the plaintiff less valuable, there may in fact be no real remedies at all. In such a situation, where the term breached is a mere representation, the plaintiff action will be based on misrepresentation. If the misrepresentation was fraudulent, that is, the defendant deliberately told a falsehood which induced the plaintiff to enter into the contract, the remedy will be won in damages for misrepresentation. Now, misrepresentation is a course or a topic rather, that you are going to learn in second semester. So I don't want to go deep into misrepresentation today. But we have 3 types of misrepresentation. Misrepresentation basically is when you know the fact about something and then you decide to fraudulently misrepresent the fact to another party. So, for example, I know that I studied law, right? and then I tell somebody that I studied medicine from the university of this or the university of that. Do you understand what I'm talking about? I know that that is not the case, but I am misrepresenting the case fraudulently to the other party. Do you understand? And also there's innocent misrepresentation and there is negligent misrepresentation. But when it comes to fraudulent misrepresentation, then yes, you can collect damages. You don't sue under breach of contract though. Do you understand? When there has been a fraudulent misrepresentation, you don't sue under breach of contract because it amounts to mere representation under breach of contract. What you sue under is misrepresentation, and then you claim damages under misrepresentation, right? Now let's continue. Previously, if the representation wasn't fraudulent, it will be regarded as what? An innocent misrepresentation. There is no remedy at all for an innocent misrepresentation at common law. There is some remedy in equity, but it is so qualified as to be almost illusory in some cases. Now, if we go to the case of Hadley, Bryan and Co. versus Ella and Partners Limited, the House of Lords held that in certain circumstances, damages can be obtained for the negligent misstatement. This has therefore created a third category of misrepresentation known as negligent misrepresentation, for which remedy for which remedy of damages is available. So therefore, you know now that you have three. You are fraudulent, right? And for fraudulent misrepresentation, you can collect damages, but you don't sue for mere representation under breach of contract because there is no damages for mere representation. What do you sue for? You sue for fraudulent misrepresentation under misrepresentation. There you collect damages. If it's innocent misrepresentation, whether under breach or under misrepresentation, there are no remedies. However, there is now a third category, which is negligent misrepresentation, which means when you say something negligently, you ought to know the opposite, yet you are saying the direct opposite of what you are saying negligently. You ought to have exercised due caution when making such statements. For example, as a doctor, I believe that when you want to give somebody injection, there are due process for you to ascertain what kind of injection. You just woke up and you say, well, I just want to do this. Do you understand? That will be negligent. So when you begin to represent as a doctor that, oh, I looked at the scan and this is it, that is it. If it's innocent, that's going to be different. But then you looked at the scan and you ought to know certain things from the scan, but because you were negligent about looking at the scan, or you looked at patient A scan instead of patient B scan, which is just negligence. Do you understand? And then you are now reporting what is patient B for patient A or something like that. So for negligent misstatements, it amounts to what? Damages under misrepresentation. That is a topic on its own. It is not here under breach of contract. I am trying to tell you, when we are talking about mere representation, what is the effect under breach of contract? Where something amounts to a mere representation but not a term of contract, you have no damages. Where something amounts to a term of contract, which I'm going to teach you in other classes, you are going to have damages of repudiation. You are going to have not damages, you are going to have a remedy of repudiation or damages depending on the nomenclature of what is broken. If it's a condition, then yes, repudiation or damages. Do you understand? But if it's a warranty, then it's just if it's a warranty, then it's just damages. Do you get? So now let's move on to the next part of our lecture, where we are talking about the English Misrepresentation Act of 1967 has somewhat increased the scope for obtaining damages for misrepresentation, but this act does not apply anywhere in Nigeria. Why? Because it's not part of SOGA, that is statutes that are of general application in Nigeria. When you are talking about statutes that are of general application in Nigeria, we should look at statutes that were in effect in England prior January 1st 1900, and in this case it's a 1967 act, so it is not applicable in Nigeria. From the brief discussion above, it is clear that the plaintiff who complains of a breach of a term of contract is far more likely to obtain a satisfactory remedy than a plaintiff who brings an action for a breach of mere representation. Now let's talk about distinguishing between the both. So we are done with this now. We are done with this. and we are done with it, especially the effect. Now we now want to distinguish between, and yeah, we are done with this too. We want to talk about distinguishing between the two terms. When I'm talking about distinguishing, we'll also talk about what those terms are. We already know what a term of contract is. A term of contract is something that is so important to a contract that upon breach, the other party can claim for repudiation or damages. If it's a condition, repudiation and damages. If it is a warranty, then just damages, right? We talked about that. Then we talked about mere representation. A mere representation is a statement, a clause, or whatever that is not so important or form part of the preliminaries of a contract, that it's more like a mere puff. It's just part of the let me say toasted, so to say, you use for a customer before you enter into the contract. Do you understand? So all those things that you used to try to get the customer to buy, those are just mere representations. They do not amount to a term in the contract upon which, if broken, you can then sue, because if you sue, there are no remedies. So we know what mere representation is. We know terms of contract. We've understood the significance of the distinction. The significance is in the effect. One, you can get remedy, the other you can't. Now let's talk about how to be able to distinguish them properly when we see them. And when we are talking about the distinguishing, Chisaya and 5 Foot, who are authors actually, gave us 3 tests to determine what is a mere representation from what is a term of contract. 3 tests. However, Trittel on contract, that is another author, Trittel also gave us 2 tests. So we have 5 tests in total. So you have 3 tests to determine what's mere representation from Chisaya and 5 Foot, and you have 2 tests to determine what's mere representation from Trittel. That's what's mere representation distinguished from a term of contract. So let's go to our note to continue. Now, in the light of what has been said so far, it is therefore essential to distinguish between a term of a contract and mere representation. Chisaya and 5 Foot have designed 3 independent tests for this purpose. The first test, so let us put our test this way. So Chisaya and 5 Foot, right? I hope I get the spelling correctly. Okay, Chisaya and 5 Foot. For those who are not Africans, I don't know if I'm pronouncing the Chisaya well, but you get the gist. So yes, we are talking about the first one, which is what? At what stage of the transaction was that statement made? Now, you know that when you are talking about, terms of contract breach, now, one party, like I said, either A or B, one party is alleging that the other party, are you listening? The other party has failed to do what that person said he would do, or what that person said initially is not what the case is now. Do you understand? So let us say that you want to buy a fridge or something, and then you went to the Igbo man shop, or you want to buy jeans, and the Igbo man say, this Oakley car is very original, don't worry, it will never spoil for 5 years, or this or that, all those kind of things. And then you now realize that it spoils in 3 months as opposed to 5 years. And when he was saying all those things, one of the questions that Chisaya and 5 Foot is telling us to look at is the time of which, at what stage of the transaction was the statement made. At what stage? If it was made further from when the transaction was concluded, okay, let us say I went to Yaba to go and buy this thing, and that day I did not carry enough money, I just wanted to price. So when I got there, I was how far I want to buy fridge, and he told me all those things, don't worry, 5 years this fridge no go spoil, all those kind of things, don't worry. See, once you on light like this, it go dey block everything where you put inside in 5 minutes, everything go dey block, all those kind of things, and all that. And then I didn't buy it on that day. Then I went there after 2 months, because I didn't have enough money then. Then I went there after 2 months to get it. According to Chisaya and 5 Foot, the longer it took between when the statement was made to when the contract was concluded would make it's going to make it more likely that that statement will be a mere representation as opposed to being a term of the contract. If it is longer, I said 2 months. If it is longer, so you have statement is made February, you came to buy February, March, April, so you bought May. There are 2 months interval. So the longer it is, that statement that is made in February will be a mere representation as opposed to being a term of a contract. That's what Chisaya and Fightful said at their first test. So at what stage of the transaction was the crucial statement made? Now the idea is that statement made at the preliminary stages of the negotiation would not be regarded as terms of contract but mere representation. Thus, theoretically, the longer the time lag between the time the statement was made and the time the contract was concluded, the more likely would it be regarded as a mere representation and vice versa, as was held in the case of Bannerman and White and Routledge versus McKay. Now, Bannerman versus White, Bannerman versus White, White, and Routledge, Routledge versus McKay, Mckay. Now, according to what Chisaya and Fightful is saying as our first rule to determine, I personally do not agree with this. I do not agree. But not only I myself, but you also have the case of Shawell versus Reed. So you have SHA something wrong. So is there any question? Okay, great. How many people online? Oh, great. Now you have the case of SHAWEL versus Reed, READE. Now in this case, for instance, where the lapse between the statement and the date of the contract was 3 weeks, the statement nevertheless constituted a term of the contract. Shawell and Reed, it took how many weeks? 3 weeks, right? That's the case of Shawell versus Reed. It took 3 weeks and it still amounted to a term, right? However, if you now look at the case of Routledge v. McKay, it was just 1 week and the court said that what? It is a mere representation. Can you see that people do not agree with this first rule given by Chisaya and Fightful? Because in Shawell and Reed, it took how many weeks? 3 weeks, and it was a term. You know that Chisaya told us that the longer it is, the more likely it is that it's going to be a mere representation, right? But that Shawell and Reed did not agree, because if you look at Shawell and Reed, it took 3 weeks and they said this is still a term. And then Routledge and McKay, it took just 1 week between the time the statement was made and the time the contract was concluded, and Routledge and McKay said no, that is a mere representation. Do you understand? So the longer here amounted to a term, the shorter here amounted to a mere representation, as opposed to what Chisaya and Fightful is saying. So you can see that rule is not usually agreed by other people. Let us look at the second rule that Chisaya and Fightful gave to us, and that was the fact that was the statement later followed by a reduction of the term to writing. Reduction of the term to writing. Reduction of term to writing. So the question we're asking here is, when you go to Yaba and then everybody's saying a lot of things and all that, as at the time when I now want to buy the fridge, I told you that it was 2 months later. I went in February and then it was saying a lot of things. Don't worry, the fridge go spoil, this thing and that for the next 5 years. You no need to call an electrician, this fridge in Akakaraka and all those kind of things. And then 2 months later I went to buy it. We've looked at time. I've said time is not something you look at, because if you look at time, court authorities has gone against it. Now Chisaya and Fightful say, okay, let us look at our second rule, which is what reduce it to writing. If at the time I'm coming back in May, I think this is May. If at the time I'm coming back in May, did I reduce those words that he has said verbally to me? Did I reduce them in writing? If I reduce them in writing, then it's more likely to be a term of a contract. If I did not reduce them in writing, there is more likely to be a mere representation. But let's look at what the note says. Now, the basic point here is that if there is an oral agreement which was subsequently reduced into writing, any term contained in the oral agreement not contained in the later document will be treated as a mere representation. I think this rule will operate if we had an oral agreement and then later we reduced our oral agreement into writing. That's when this rule will operate. Because if we had an oral agreement and at the time we were concluding the transaction, we did not have writing, we still concluded an oral agreement, this rule will not operate, because then all the terms of the contract, all of them was made orally. So the fact that we did not reduce this should not take it out. Do you understand what I'm saying? So, but if we had an oral agreement in February, and when I came in March, we then reduced all our agreements into writing, but that thing, let us say the fact that he said that the fridge was not going to spoil in 5 years, that statement that he made, we did not reduce it in writing in May when I came. Are you listening? We reduced other things into writing, but we did not reduce that into writing. Now my fridge now spoils in 3 months. Can I now sue him for that thing that he said that it would not spoil in 5 years? Can I sue him? That's the question. So I can't if it was reduced in writing by May rather. So we move on. So this is probably the least useful of the three tests, because it is much easier to cite cases in which the test was ignored, as we can see in the case of Birch, BIRCH versus Paramount Estate, PARAMOUNT Estate, STATE, and the case of Esso Petroleum versus Mardin, ESSO Petroleum, PETROLEUM versus Mardin, MARDEN, than those in which it was applied. So this rule was applied in just one case, Helbert versus Buckleton. Let me spell it on board. Helbert versus Buckleton. Now, in this case, this rule was applied. But in those two cases that I cited earlier, that's the case of Birch versus Paramount Estate and Esso Petroleum versus Mardin, they discarded the rule. Now, what is Chisaya and Fightfit trying to think about here? I need you to understand that these are authors who are looking for the best way by which we can distinguish and differentiate between a mere representation and a term. So the fact that Chisaya and Fightfit has said something doesn't mean that all courts will agree. Some courts will agree, some courts will disagree. Do you understand what I'm saying? So now in this case, when you talk about reduction of the term to writing, now we have Helbert versus Buckleton. They agreed that if the first time when it was made in February, the words were made were orally, and then later by the time the contract was concluded, it was concluded in writing. But then what you are suing upon right now, it was made orally but it was not reduced in writing later, then you cannot say that you can sue on that, because if it wasn't reduced in writing, then it was a mere representation. Do you understand? That is what the rule is according to Helbert versus Buckleton. But you have certain cases that did not follow that did not agree with that. They are saying that no, the fact that it was not reduced in writing does not take it away. Do you understand? Does not take it away from being a term. It can still be a term regardless of whether it was reduced into writing. And I cited those two cases earlier for you. And then we go to the third rule. I told you that Chisaya 5 foot said, 3 rules, gave us 3 rules before we then look at the rules that were given to us by Trittel. How many hours is it now? 38 minutes. Okay, good. And there are no questions, right? Okay, that's good. Now, moving on, we go to the third rule where we talk about give me a minute. Where we talk about one party's superior knowledge. Now, number 3, superior knowledge. Number 1, at what stage of the transaction was the mere puff made or the mere representation made? If it was made longer than when the contract was concluded, then the longer it is, the more likely that it is a mere representation. Some courts agreed, some courts disagreed. If you look at, and also you have these cases, if you look at reduction into writing, if as at the first time it was made orally, right? And then as at the time when we were concluding our we wrote our terms down, or we wrote the whole contract down. But that thing that we said in the initial point, that is maybe a week ago, 2 weeks ago, when I came to meet you, the time you were talking to me, you told me some things. The things you told me 2 weeks ago, we did not write the one which I'm suing on now. We did not write it in writing when we were concluding our contract. If we did not put it in writing, then what would the court say? The court will say, no, because you did not put it in writing, then nothing that was said initially, upon which you are suing now, will just be a mere representation and not, a term of a contract. But this is the only case that agreed with it so far, and then you have some other cases which agreed with it. Obviously, I'm just giving you one of the cases that agreed with it, and then we have two. Check it back. It would not be strong because it's not fine. So yes, can everybody hear me again? Can you hear me now?
Yes.
Let me see the screen. Is it clear?
Yes.
Okay, so let's continue. But the one before was clear, right? Yeah, because it's hotspot. Where did I stop when I was teaching? Yeah, I think I stopped at where we are talking about one party's knowledge as opposed to the other. So when we are talking about a party with special knowledge, for example, when we are talking about a party with special knowledge, it is person that has special knowledge. What that person says. So we have A, let's say we have C, and we have D. This person has special knowledge on the subject matter of a contract, right? What this person says is more likely to be a term than a mere representation. That's what we're saying, that special knowledge. So if this party who does not have so much knowledge on the subject matter says something, is more likely to be a mere representation than a term. So if it's from the person with special knowledge, it's more likely to be a term. If it's from the person who doesn't have so much of special knowledge, it's more likely to be a mere representation. Do you understand? Is this still clear? Okay, good. Now, so what is the authority for that? Oscar Chess Limited versus Williams. OSCAR Chess CHESS Limited versus Williams. That's our authority. And what is the authority? What does the authority say? It says that the statement is made, if however the statement is made by the person who has less, that's C, by the person who has less knowledge about the subject matter of the contract, it is regarded as what? As mere representation, right? That's the case of what? Oscar Chess and Williams. But if the statement is made by somebody who has more knowledge in relation to it, according to the case of Dick Bentley Production Limited versus Harold Smith Motors, and the case of Shawell and Reed, it tells us that if the person has the special knowledge, then it's more likely to be a term than it is a mere representation, right? Let's continue with the notes. Now, this test is by far the most successful of the three tests by Chisaya and 5 Foot, and some of the cases that contradict the other two tests can be explained in this third one. So in the case of Shawell and Reed, and also in Esso Petroleum versus Martin, although the time lag 3 weeks was much in one case, there was a later document not containing the statement in the other case. If you understand what I'm saying, when we are talking about Shawell and Reed, because of the 3 weeks rule, right, stage of this thing, transaction, the 3 weeks, they said that it was a term, right? But if you look at this one, if you look at Esso and this Mardin, in the case of Esso and Mardin, we are talking about somebody who said something but was not reduced into writing. So you see that there have been inconsistencies in relation to the first and the second test. But almost all these cases that are contradicting each other in relation to first and second test agreed on the third test. So when in each case was made by an expert and relied by a layman, and in both cases the statements were held to be terms of contract. So let's look at the case of Oscar Chess versus Williams, for example. In the case of Oscar Chess versus Williams, it represents the reverse situation where the layman gave wrong information. Now that's C. In Oscar Chess versus Williams, who is the layman here? C, right? While D is what? The expert. right? In relation to this rule, special knowledge, we must look at the parties, one as a layman, one as an expert. Now, where the layman gave information about the date of the manufacture of his car, or to the of his car to the expert, the car dealer, that's the expert is the car dealer, it was held that the statement was a mere representation. Do you understand? Now, what are we saying here? We are talking about somebody who told the car dealer that, oh, on so dates they manufactured my car, blah blah blah, and then he is the layman, and then the car dealer, I don't know how that formed a problem that got to court, upon which they want to sue and stuff like that. But that statement as to the date of the manufacture of the car made by this one who is the layman was held to be a mere representation. Why? Because the expert in car dealership, that's this one, should know certain things regarding, date and manufacture of cars. So if this one who is a layman just says anything, it would be a mere representation, as opposed to when an expert with special knowledge says that same thing. It will not be termed as a mere representation because you have special knowledge. Do you understand? Is this still going? Okay. Is it clear?
Yes.
Okay. So moving on. Now we are done with the three tests as given by Chisaya and 5 foot. And I hope that you understand our three tests. When you get into the exam hall and you have a question on mere representation, it is very important for you to write these three tests given by Chisaya and 5 foot and their cases, and also give your submission as to the fact that the first and the second test are not as important or as potent as the third test given by Chisaya and 5 foot in relation to special knowledge. Do you understand? And you have to give your reasons and your cases as to why they are not as important, and then submit that the third test is one which is so much looked upon by the court. Do you understand? And then you then get to the second test, which is that of Trittel. We are talking about Trittel now. I told you that Trittel gave two tests, right? Trittel gave two tests. Trittel gave two tests, right? While Chisaya and 5 foot gave three. The first test given by Trittel is known as the verification test. So yes, it was said that this was that this advice negated any intention to warrant the soundness of the boat. So what are we talking about here? We are talking about verification. If the buyer, not necessarily the buyer, but a party, said something, it is upon that thing, because that thing did not turn out to be whatever it is that you wanted it to be. It is upon that thing that you are suing in court. What's the problem? It is upon that thing that you are currently suing in court, right? Upon the thing that somebody has said that you are currently suing in court, right? Now, if person, when he said that thing, he told you, go and verify to see if it is true, that makes it a mere representation, and it cannot be a term of contract upon which you can sue. Do you understand the point of view where Trittel is coming from, right? So in this case now, we had somebody who was doing a boat, boat seller, and then the boat seller said, this boat is sound, it's very okay for you, don't worry, very sound, but just make sure that you tell somebody to check it. Do you understand? So or that fridge seller that I said earlier, although he was telling me, the fridge, don't worry, but carry your own electrician come, may you come check am, I go allow you go check am now see the sound. Do you get? If there is that statement where the other party has told you, go and verify, like Peter Obi, go and verify. If the other party tells you go and verify, then that cannot be a term upon which you can sue the person. That can only be a mere representation. Do you understand? You can't sue the person on that term anymore, because the person already told you to what? Go and verify. Do you understand? So let's continue with the notes. Now, on the other hand, a statement is likely to be a term of contract if it is intended to prevent the other party from finding out the truth and induce him to enter into the contract. Let's look at the case of Shawel versus Reed. Now, the plaintiff, who wanted a horse for breeding purposes, started examining one that was advertised for sale. The defendant interrupted him, saying, "You need not look for anything. The horse is of perfect sound." Now, the plaintiff bought the horse 3 weeks later and discovered that it wasn't suitable for stud purposes. The statement was held to be a term. Now, I noted something. It will be recalled that this decision was considered as being based on superior knowledge of the defendants. Now, I want you to look at something. I want you to look at this verification rule in relation to superior knowledge and this verification. Now, in the case of Shawel and Reed, there was horse that was being advertised, and the plaintiff was standing. He was looking at the advertisement. Do you understand? And then the other party then came and said, don't worry, you don't need to look too much. This horse is of perfect sound and is of perfect this and is of perfect that. Don't worry, you don't need to look too much. You don't need to do so much. Do you get? And then because of what he has said, now this is the verification. Verification is two-pronged. Number one, if the person tells you that go and verify, it is a mere representation, right? Now the second prong is that if the person hinders you from verification, then it's a term. Now, in that case where that man was standing, it falls under verification because that party hindered him from going to do any other further investigation or as to the horses. He told him, what was the statement? You need not look for anything. The horse is perfectly sound. You need not look for anything. The horse is perfectly sound. Are you listening to me? You need not look for anything. That was the statement. Now, the question is, does that statement amount to a mere representation or it amounts to a term? Now, if you apply this rule, superior knowledge, because that person is an expert in horses, do you understand? The person who made that statement, because he's an expert in horses, he falls under Chisaya and Fightfoot rule. Assuming he wasn't an expert in horses, he wouldn't have fallen under this rule. But that person is an expert in horses. Therefore, it falls under Chisaya and Fightfoot rule. But under the verification rule by Trittel, he falls there because his statement hindered the other innocent party from making further verification as to the subject matter, as opposed to our first case of Ike and Godfrey, where he told him, go and verify. Can you see how Shawel and Reed, this case, this is a very important case. Shawel and Reed comes here and comes here. Can you see now? It comes here because he was an expert who made it. And the superior knowledge rule applies to say, to remove that statement. You need not look for anything. The horse is perfectly sound. Do you understand? That's what he said. You need not look for anything. The horse is perfectly sound. Because an expert made that statement and then did not realize that the horse was not perfectly sound, he sued and said that that statement was a term. If you come under superior knowledge, you are fine. If you come under verification, because his statement, not because he was an expert that made the statement, because his statement was made which hindered you from further verification, yes, this one still applies. Are you following? So that is how to use Shawel and Reed in relation to superior knowledge and verification. Do you understand? So I think we are done with that. And then the second test is the degree of importance. Degree of importance. Degree of importance. So now the Twitter test is that the degree of importance attached to the statement by representee. Thus, if the representee can demonstrate that to the knowledge of the representor, he would not have entered into the contract if the statement of assurance had not been made, such a statement will be regarded as a term of a contract. So when you're talking about the degree of importance, you are saying that that person made a statement, and it's because of how important that statement was and how much I relied on the statement. That's the reason why I entered the contract. Are you listening to me? When you are talking about degree of importance, I can say that it applies also to shower and read, because when the other party was looking at the advertisement and he was like, oh, should I do this, should I not do this, he would have naturally wanted to verify whether the horse was of perfect sound. But the other party came and said, no, you don't need to verify, the horses are of perfect sound. Not only did he say, oh, don't worry, you don't need to look for anything, the horses are perfect, which falls under the verification rule to turn it into a term of a contract as opposed to a mere representation. The degree of importance also apply, because the other party would say that, well, I relied heavily on his statement. The degree of importance of his statement was so much that was the basis upon which I relied when entering into the contract. Do you understand that? Let's look at the case of Bannerman versus White. In the case of Bannerman versus White, to a prospective buyer of hops, HOPS, asked the seller whether the sulfur had been used in their cultivation, adding that if it were so, he would not even bother to ask the price. The seller's assurance that the hops had not been treated with sulfur was held to be a term of the contract. So now in Bannerman and White, the second case here, Bannerman, I think I said this case earlier, versus White. In Bannerman and White, we have somebody who wants to buy hops, HOPS. Somebody wants to buy hops, and then he told the seller, please, hope this your hops is not treated with sulfur. Because if it's treated with sulfur, I would not even bother asking for the price. And then the other party then says, oh, don't worry. It's not. Who said, oh, no, don't worry, it's not treated with sulfur? Said it 4 months ago. Are you listening? Applying this stage of contract. You know that he said it in February, and then the person bought it probably in August. But in February, he already told him that, I don't want to buy hops that was treated with sulfur. I want to buy the one that is not treated with sulfur. So if we are to go buy Chisaya and 5 foot, that will not amount to what? A term, because of the time lag. But that doesn't make sense. But when you look at it from the perspective of a degree of importance, the essence of buying the hops itself, the essence was because he told me that those hops did not have what? Sulfur. They were not treated with sulfur. That is the reason why I bought them. Do you understand? That's the degree of importance. It was based on his statement, upon which the degree of importance was so high, upon which I then entered into the contract. Do you understand? Because the degree of importance of what he has said was so high, that's why I entered into the contract to buy the hops from him. Can you see? So we travel through stage of contracts, to reduction of term to writing, to superior knowledge, to verification, and then to degree of importance. And these are the tests that you use when you are determining whether something is a mere representation. Now you know that these tests can be used interchangeably. When you are making your arguments, either in exam, you should understand that these two tests are usually not relied upon so much. The tests are relied upon that does not mean I should not state them in exam. The fact that they are not relied upon doesn't mean they should not be stated. They should be stated, but it should be shown that because of the discrepancies and how it does not meet the standard in relation to distinguishing between a term and a mere representation, courts do not follow these two tests. However, the courts are more likely to follow the superior knowledge test, the verification test, and then the degree of importance test. Any of them will suffice. It need not be that you have to prove the 3 of them. No. What you just need to prove is one of them to suffice. Do you understand that? And with that, we are done with distinguishing between both terms. And then we go to our last part, which is collateral contract. So collateral contracts, what are collateral contracts and how do they affect us in our class for today? That's what we'll be talking about right now. What's time now? On it. 1 hour, 59 minutes. Okay. So, is there any questions so far? How many people are there?
13.
Is there any questions so far?
Someone was asking if you, I think
If what? Yes, we'll attempt the past questions in subsequent classes, not in this class. So the person asking if we are going to attempt past questions, that will be in subsequent classes, not in this class. I would appreciate if questions are asked about what I'm teaching so far, and all that. Any other thing? Okay, let's move on. Collateral contract. Now, even where due to its failure to satisfy the above tests, are you listening? Where a clause, due to its failure to satisfy the above test, a statement cannot be regarded as a term of a contract. The court will still give the representee an effective remedy by resort to the device of collateral contract. Because it fails, that it is when it doesn't fail that we then give it to a term of a contract, right? If it's a superior knowledge person, it's term. If it's verification, it's term. If it's not verification, that if it doesn't pass the verification test, then it's mere representation. If it's made by C, who is a layman, it's mere representation. Do you understand what I'm saying? So if it fails any of these tests, what do we do? If it fails any of the tests, what the court will do is that the court will still clothe the person with something in order to find a remedy. That something is known as collateral contract. Do you understand me? Now, when we are talking about collateral contract, what does it mean? According to this doctrine, if the representor makes a statement of promise which is intended to induce the representee, so let us say we have P and M. This is the representor makes a statement of promise intended to do what? To induce the representee into a contract. Then if the representee M enters into the contract in reliance of that promise, the representor will be held bound by his promise. Are you listening to me? There is a promise made by the representor. It's just that promise did not amount to it didn't pass any of these tests. If he had passed any of these tests, we need not come under collateral contract. All we come under is what? The main contract, term of a contract. But because he did not pass any of these terms, he is regarded as a mere representation. But in order for people not to start saying things anyhow, in the hopes that to fall under mere representation, then the court now clothes people with what? Collateral contract. So if the representor makes a promise that induces the representee M to enter into a contract, in reliance of that promise, the representor will be held bound by his promise. The promise is treated as a preliminary or collateral, that is usually oral, which takes the following form. If you agree to buy my horse, I promise you it will be good for breeding purposes. Let me use another example. If you agree to buy this fridge, that Igbo boy, he said, if I buy the fridge, that is going to be what? It's going to last for how many years? For 5 years, and I would not need to repair it. You understand? Now, because he said that, are you listening to me? But that statement did not pass any of these tests. That would ordinarily mean that I would not be able to sue him. Even when my fridge spoiled 3 months instead of 5 years. He said that it won't spoil in the next 5 years, but then it spoiled in how many months? In 3 months. Now, because he has said that would what? Be a collateral contract. This collateral contract now induces the representee. You as a person, if you go and meet somebody selling fridge, and then the person tells you that if you buy this fridge, that is not going to spoil in the next 5 years, won't it induce you to buy the fridge? Do you understand? When someone is telling you this fridge, nothing, and he's also telling you that once you put drink inside it, it will block immediately, like it will turn to block. What will you do? You want to buy it now. So this collateral contract now induces the representee to enter into the main contract, which is what? Buying of the horse. If you buy my horse, I promise you it will be good for what? Breeding purposes. Then because he heard that it's going to be good for breeding purposes, then he bought the horse. He said the fridge, if you buy the fridge, it's not going to spoil in the next 5 years. Because I heard that it's not going to spoil in the next 5 years, then I bought the fridge. Then collateral contract would be used upon which I can sue. Let us see the case of City and City and Westminster Properties Limited versus MUD, MUDD. City and Westminster's Property versus MUD. Now the defendant lists of the plaintiff property came up for what? For renewal, right? And then the plaintiff inserted a clause. Now, what are we talking about here? When you're talking about leases are like rent. So I rent my house for 5 years, and then after 5 years, so let's say I rented my house in 2015. This is my house here. I rented it in 2015, right? And it's supposed to last for, the lease is supposed to last for 5 years. And who did I rent it to? I rent it to Mr. Thomas. That's Mr. T. This is my house. Rented it in 2015 to Mr. T for 5 years. So when is Mr. T supposed to give me back my house? 2020, right? Now we are in 2020 and Mr. T is supposed to give me back my house. So, but then Mr. T wants to renew for another 5 years. And then the plaintiff inserted a clause. That's me. I then inserted a clause restricting the use of the premises. That is telling Mr. T that you can no longer use this house except for showrooms, workrooms, and offices only, thereby prohibiting Mr. T from sleeping on the premises. Previously, from 2015 to 2020, he could. But now that he wants to renew, you know that contract has expired. We have a new contract of offer and acceptance now. He wants to renew, and I want to accept, but I am changing the terms of the contract. And I'm telling him, if you are going to accept this one, no more sleeping on these premises. The premises are only for what? Showrooms, workrooms, and offices only. No more sleeping. And then what did the defendant do? The defendant, who to the plaintiff's knowledge has been sleeping, so I knew that Mr. T was sleeping there, right? Objected to the clause. Mr. T now said, no, I don't agree that one. No, I want to be sleeping on the premises, and all that. And then I assured Mr. T, and was assured by the plaintiff agent, that if he signed the lease, I told Mr. T, don't worry, if you sign the lease, I will allow you to continue sleeping on the premises. Are you listening to me? So initially, which was in the paper of the contract, the document, no more sleeping on these premises, right? Why? Because of what is it called? Sorry, we don't know the why, but no more sleeping on the premises. You can only have showrooms, workrooms, and offices. That was what was stated in the contract. Do not forget that when we have it reduced into writing, anything that is said outside it orally, I then agreed with him orally. I told him that, don't worry, just sign it and pay and do your thing. You can continue sleeping, even though it was in the contract that was only for showroom, workroom, and offices. I told him, don't worry, sign it, you will continue sleeping. Are you listening to me? And then he signed it. And then do not forget that because we have reduced it into writing, anything we say outside it will not be read into the contract. It will be right when it has been reduced into writing. Now, the plaintiff now brought an action for forfeiture of the lease against him on the ground that he has broken the covenant restricting the use of the premises. So what are we saying here? The same plaintiff that told him, don't worry, sign it, you will sleep. We are not going to disturb you. Then the same plaintiff now sued him after they found him sleeping there, after he has signed it, and said, my lord, look at the term of the contract. What does it say? My lord, it says no sleeping. My lord, he slept on it, and that is slept in it rather, and that is a going against a breach of the covenant, that is of the condition of the contract. And then what did the court hold? It was held that although he had broken the term of the lease, he was entitled to sleep on the premises on the basis of a collateral contract in which the plaintiff promised to allow him to do so. Thus, in this case, the collateral contract took the form of, if you sign the lease, I promise you can continue to sleep on the premises in spite of the express term of the lease. The main contract was simply the leasehold agreement itself. So you can see that. Can you see that? If you sign the lease, I promise that you will continue to sleep regardless of what has been written in the main contract. So you see, if you sign the lease, it's for main contract. I promise to is the collateral contract. Do you see that? So let me give you an example. If you buy the fridge, for example, this one is on main contract. it will last for 5 years without repair. Now, this will form the basis of the collateral contract upon which I can then sue. I cannot sue on this because it might fail this terms test to determine if it's a term. How do we determine if something is a term? Verification, degree of importance, superior, blah blah blah. To determine if it's a term, we have to look at this, right? Now, this statement, it will last you for 5 years. It failed this test, right? So therefore it cannot be said to be a term. It is what? A mere representation, right? So because the courts do not want people to keep saying things and running away from achieving those things or doing those things because of, oh, it is a mere representation, that part, this latter part, would then form what? Would then form a collateral contract. So if I'm the lawyer for the person who was told this, I'll be smart enough to know that this thing is likely not to be a term. Or even if I want to file my argument in court, I will argue, number one argument would be that it is a term, and then I will try to wiggle my way into one of these. But my number two argument, my lord, even if the number one argument doesn't fly, if you hold that it is not a term, my lord, I argue that even if it is not a term, that's arguing without conceding that it is not a term, my lord, it is a collateral contract. Then I then make this argument. Do you understand? So if it's a term, my argument has, the first argument fly, right? The second one, cancel it. If it's not a term, the first argument does not fly, but the second one will fly. Do you understand? So that is how you make your argument. If it's an exam, this is the same thing you are supposed to do. When you see that something is a mere representation, you can, after you've made your own test as to whether or not it's a term, you start with Chisaya and Fight Food test, then you go to Tritel test. When you have done all those tests, you have done your cases, you have done, and you have concluded that it is not a term, you can then write, however, this can amount to a collateral contract. Cite this case of City Westminster Properties versus Mod. Cite it and then tell us how, though something might not amount to a term, because according to the court it's a mere representation, but it can form the basis of an action for collateral contract. Do you understand that? It can form the basis of an action for collateral contract. And with that, that's where we end our class for today. Sorry for this moment. Is there any questions? Is there any questions on amendment?
1 hour 20.
Okay, so is there any question right now before I close the class? We have another class on condition and warranties coming up soon.
I don't understand Bannerman and White case.
Someone doesn't understand Bannerman and White. Okay, let's go to Bannerman and White. Is there any other question? Please ask your questions as I'm explaining this. Bannerman and White. That's on verification now. Degree of importance. Right? Okay, let's read the fact of Bannerman and White. Now, to a prospective calling, who is always calling me? You know what? Since I'm using hotspot, sorry. Yeah, so can everybody hear me now? So in Bannerman and White, we are talking about somebody who had what? Who wanted to buy hops, HOPS. And then he asked the person, these hops, hope they are not treated with sulfur. If they are treated with sulfur, I don't even want to buy at all. Okay, you know that there are certain Muslims that do not take alcohol. They are so keen on not taking alcohol at all. So even as little as they want to buy cake, they will ask you, hope this cake, not alcohol is used in cake to preserve the cake from spoiling on time or something like that. So the Muslims usually ask the people making the cake, I don't want alcohol in my cake. So imagine somebody telling, see, I'm a Muslim and I don't want you to add alcohol in my cake at all. And the person says, no, don't worry, I will not add alcohol in your cake. It is upon the fact that the person was not going to add alcohol, because the Muslim told the person, if you add alcohol to my cake or you add alcohol to your cakes anytime you make them, I do not buy from you. And then the person said, don't worry, I will not add alcohol to the cake. And then the Muslim now later find out that the person added alcohol to the cake. Are you listening to me? In that instance, the fact that it was expressly stated that the person would not add alcohol to the cake forms something of degree of importance. That statement cannot be said to be a mere representation because of its degree of importance. He wanted to buy hops, and then he told the person, hope your hops are not treated with sulfur, because if they are treated with sulfur, I would not bother buying them. And then the person told him, don't worry, they are not treated with sulfur. That statement, they are not treated with sulfur, cannot be regarded as a mere representation because of the degree of importance which the other party attached to that statement, which is upon which he then entered into the contract. The Muslim asked the other party, hope you don't put alcohol in your cakes, especially in my own. If you know that you put alcohol in all your cakes, I cannot make an exception for me. Don't worry, I know they do. And then the person said, don't worry, I will make cake for you, but there will not be alcohol inside. And then the Muslim said, okay, give it to me. And then all of a sudden, the Muslim now found alcohol inside. And then the other party wants to collect his money. He said, no, I'm not going to give you the money, because I told you. And then the other person said, that was a mere representation. It's not a mere representation. The degree of importance of that statement was so high that it was upon the statement that made me that you're not going to add alcohol to the cake that I entered into a contract of buying that cake from you. The degree of importance of that statement was high. That was why I bought the cake from you. Do you understand? That is how one of the ways you distinguish between what is a mere representation from what is a term of a contract. So, is that understood? Who asked the question? Anu? So, Anu, I hope I've been able to answer your question well. If you have further questions, please let me know. Does anybody have any other question? So I'll give you just 1 more minute. In case there are any other questions, I want to go and rest now and charge my phone for our next class on conditions and warranties. So 1 minute before we go, in case there are no other questions. There's still no other question? Okay. So it was beautiful having a class with you guys. Thank you for watching from the beginning of the video to the end of the video. That's to our lecture for today. I will see you guys in the next 1 to 2 hours thereabout. I'll send the link to the group chat. I'll see you guys in the next 1 to 2 hours, where we'll then be talking about our next lecture on conditions and warranties, as terms of a contract and all that. So thank you so much for watching to the end of the lecture. I will see you in my next class.